Welcome to In the Courtroom and the Boardroom, Business Law and Litigation with Colleen McKnight.
Hey there, you're listening to In the Courtroom and the Boardroom with Colleen McKnight, attorney and founder of McKnight Law. My name is Kevin Rosenquist, and today we're breaking down a question more business owners should ask before they sign a contract. Should disputes go to court or arbitration? Colleen, welcome back. Good to see you.
Thank you so much. I'm so glad to be here.
Yeah, so arbitration versus court, what's best for your business dispute? So why is this an important topic to you?
So a lot of businesses, I would say 10 or 15 years ago, started adding arbitration clauses to their contracts or their terms of service just kind of as a matter of course. There was this sense that arbitration was faster, it was less expensive, it was less public. And we've kind of seen a shift back from that. And so as a business owner who gets to write your own contracts, this is a big question I get. Do we waive a jury trial? Do we disclaim a jury trial? Do we send this to arbitration? And Kevin, as we've talked about in the past, where you choose your fight is a big part of how your fight is going to go, right? Choosing your battleground. And as somebody contracting, you can choose arbitration in most instances. And so the question is, do you avail yourself of that opportunity or do you go to the courts?
So what's the big difference between these two choices?
Yeah, so for a little bit of background on arbitration, it's essentially a private court. Arbitration says rather than going to the judge that was appointed or elected, we're going to choose an arbitrator together. Sometimes we're going to choose a panel, maybe 3 arbitrators. I choose one, you choose one, and our choices will choose the head arbitrator. And we're going to go before them. They're going to have their own set of rules that might differ, often do, from the federal or the state rules. They have their own procedures, and it's private. So rather than being open, which our Constitution requires that our courts be open, this is something that we get to resolve privately. When you're talking about something like a sexual harassment claim or a consumer injury claim, sometimes as a company, you really want that to be private. You'd rather it not be in the public eye. And a lot of employers will require arbitration from their employees. And that keeps that fight with the employees somewhat private. They're not having to deal with what comes out in discovery or what gets filed with every other employee who can now see it. One of the things that arbitration is often touted as is less expensive and faster. I'm not sure that it's either of those things in my experience. I think it is more flexible, and that can be to your advantage or to your disadvantage, depending on whether a strict adherence to the rules is going to help you in this case, or whether you're going to need a little bit more leeway because strict adherence is going to cut you off.
So businesses a lot of times include mandatory arbitration clauses in contracts. Is that kind of what you meant before about requiring employees to go to arbitration?
Yes. So lots of times in your employee handbook or in your employment agreement, it will say if we have a dispute that arises out of your employment, you have to take that to arbitration. You don't get to just take it to the courts.
Okay.
Arbitration is interesting because with very few exceptions, the parties split the costs, right? And so if you're talking about a big business to business dispute, you kind of can tell, okay, we're each going to pay the arbitrators. We're each going to pay the system over the arbitrators. We're going to both be in this, and it's not simply a filing fee and I'm spending more money. That's not true of discovery, but it is true more of the arbitration process itself. Most arbitration, well-known arbitrators at this point, which is AAA, JAMS, there's several international groups, have changed it for consumers to businesses, sometimes for employees, because they recognize that David Goliath situation there, that simply the costs of splitting it equally would keep a consumer from bringing a claim.
So what are some of the biggest pros to arbitration, especially when you're talking about small businesses?
Heads up, I don't think arbitration is great for small businesses. I think as a general rule, as a small business, you're going to want to be in a court. I think you can get there faster, especially with things like temporary restraining orders. Let's say an employee walks out and you've proven they took things on their laptop. You got to get there quick. And arbitration takes a little bit of time to get started. I can run down and get a TRO today in Texas state court and sometimes in federal court as well. I think for most people, when you're talking about what are the benefits of arbitration, it's the privacy, it's the ability to pick your jurist, right? If you don't have any confidence in the jurists that you would be before in your jurisdiction or your venue, you might say, hey, I want arbitration because I trust these arbitrators more than I trust the judges. And you may want that flexibility of rule. I did look at some stats before we chatted, and sometimes it's faster and sometimes it's a little less expensive. But discovery, which is usually the most expensive part of any case, happens in arbitration just as it does before the courts. And so I truly don't see it really saving clients money.
Is that, would you say that's like one of the bigger misconceptions? Like what do you think are the downsides maybe that business owners get wrong or don't realize?
Yes, I think it's not necessarily less expensive. It's not necessarily faster. And I think the flexibility of rules often cuts against parties. There's more leeway for extending deadlines. There's more leeway for maybe not doing things by the book. And if you're expecting to do things by the book, that can really cut against you. I think the biggest risk and the biggest misconception is that these arbitrators are paid and they want to be chosen again. And so often what you hear is more often in arbitration, they split the baby, right? Which is a reference back to King Solomon in his famous case with the two mothers where he said, fine, cut the baby in two. And the real mother said, not a chance, give it to her. And the mother who'd already lost her baby said, that sounds great. Strange biblical story, but often with an arbitrator, what you'll see is even if you were right on everything, they're going to find a way to give something to the other side because they want to be chosen again, because that's how they make money. And often it's just easier to say, well, you win on this and you win on this, because there is no appeal. There is no one to come in and tell them you got it wrong and we're sending it back. The arbitrators are the final determination, and you just take your judgment then to a court to get it enforced. And so oftentimes that lack of appeal and knowing that the arbitrator is going to kind of try to make everyone happy means everyone is unhappy, as it is often with a true compromise, and you're stuck. There's no other recourse. You cannot appeal it.
When it comes to the arbitration clause, are you able to negotiate that or even remove it from a contract, or is that pretty tough?
It really depends on the situation. If you're buying an Apple Watch, and the terms and conditions that come with that Apple Watch say you're going to arbitration, there is no negotiating it. When you purchase that Apple Watch or that, Nike Fit device or whatever that is, you're stuck. And there's some constitutional protections and things that courts have put into place to say, hey, we don't allow, let's say it is Nike and they're based in Oregon. Oregon law may not allow Nike to put an arbitration clause for consumers in their agreements. Texas does, which if you're a business and you want to throw an arbitration clause in your terms and conditions that come with something, you're going to want to have a principal place of business in a place like Texas that's going to allow you that freedom. But as a general rule, when you're talking about click-through agreements, the ones that none of us read, sure, terms and conditions, you click it, chances are there's an arbitration agreement in there.
Okay.
Right. And we saw a couple years ago, I don't know if you remember this, there was someone who got very hurt at Disney, and they brought a case, and Disney's lawyers went and said, well, the grandpa signed up for Disney Plus, and Disney Plus has an arbitration provision that says it covers anything arising with anything to do with Disney. So we're kicking this to arbitration. Well, they got roasted in the
I'll
public.
bet.
Yeah. Yeah. They got roasted in the public square. And that's one of those times where you think just because you can doesn't mean you should.
Yeah.
Right. And so, you might have signed up for something like Disney Plus and not realize that that's going to govern your dispute with your slip and fall in a Disney store in the Mall of America, right? Like, why would that apply? Well,
Why would they go together? Yeah.
right. That's how that arbitration agreement works. But if you're an employee and that's in your employment agreement, you can absolutely push back and say, look, I'm not happy with this. If somebody here really hurts me, I don't want it hidden from public view. You're going to have to weigh that against how much do you want this job, and what are your risks if they think that you're already preparing to make trouble or be somebody
That's
who's
true.
vexatious, right?
That's very true. Yeah.
And in a business to business situation, often what I find is it's a question of leverage, right? If you're the big oil company and I'm a small service provider, the big service company or the big oil company is going to demand their paper, and their paper might have an arbitration clause. And at that point, you don't want to be the one picking it apart at that level, right? We're going to fight about indemnity. We're going to fight about limitation of liability, and we're going to get out, because otherwise they're going to say, you're not worth the trouble. I'm going to find another small service provider. But if you're on equal footing, or that they really do want the service you're providing because it's unique, you can say, I'm not willing to agree to that arbitration provision. I want to be in front of a court that's going to be held accountable by an appellate court or by the voters in the next round. And I'm not interested in your arbitration provision. I also see this often where companies just are terrified of juries. And so the contract will have, it's fine that we go to court, but we're going to be before a judge. I am a true believer in the jury system. I believe that a jury most often gets it right. That being said, I understand there's value for certainty, and the jury is often one of the most uncertain aspects of litigation. So
Sure.
I don't recommend a jury waiver, but it's not something I usually push my clients on one way or the other.
Once a dispute starts, can you avoid arbitration somehow if that's in the clause? Are there ways that it can change and end up going to court?
It's pretty rare, Kevin. The courts have said, look, especially in Texas, if you contracted to go to arbitration, we're going to send you to arbitration. You agreed to that. We're not going to get in the way of the parties' agreements. There are some cases, for example, with my client who's a Navy veteran who has a USERRA claim. That statute has said you cannot force a service member who's been discriminated against to go to arbitration, regardless of whether or not it's in their contract. They get a right to come before the U.S. courts. They served our country. There's a few others that are like that, where the courts have said, we don't think that you get to put this person in privacy. And what you've seen sometimes, I think it was Scarlett Johansson in one of her fights with the studio, where you bring the lawsuit in court, you make the fight public, and then the other side compels it to arbitration and you go fight it out. And maybe you've gotten what you wanted out of the public knowing that you weren't being treated fairly, or there was gender discrimination in your pay. And so sometimes when you want that privacy of arbitration, you may not get it completely, because someone might bring the lawsuit before you can compel it to arbitration. But what we often see is that judges say, if you contracted for this, you're going.
Right. Are there situations where you find that where businesses are actually benefit from a more public trial and not keeping it secret?
I think that there can be instances where courts and more public is better for the company, especially if the company is in the right. Right? If you know that claim is out there and then it gets swept away to arbitration, no one knows what was found. They only know that there was a claim against you and it looks really ugly, right? And we know from fights that are in the public eye right now, if you look at the Blake Lively, Justin Baldoni suit, right? She brings her claims and they looked pretty damning.
Sure did.
And then he brings his defenses and it completely changes the story.
Yep.
And you realize, oh, this wasn't what I was led to believe that it was. At least that's my view of it.
Yeah.
And so if Justin had swept it away to arbitration, all we would know as the public was her claims and none of his defenses.
Right.
So sometimes if you're the company and you're saying, no, I'm in the right here and the public needs to know that I'm in the right, I'm just going to stay here in court and let the public know that I do wear the white hat and I stood by integrity in this. And I want them to know that.
Do you advise when you're advising clients, especially particularly with contracts, do you feel the arbitration clause is generally a good thing, generally a bad thing, depends on the company? How do you usually coach?
Yeah, I'm not a huge fan of arbitration in the clauses. Like, I'm happy to fight in arbitration. I don't dislike it as a forum. But I don't know that you get the benefits that you think that you're going to get. And I think the lack of appeal and accountability for the arbitrators is a major downfall for them. And I also think that I've just seen too often where someone should win completely and they end up getting a portion of justice because the arbitrator splits the baby.
Okay. Yeah. Yeah. Is that sort of like when you're deciding, clauses aside, when you're deciding with a business whether to do arbitration or go to a jury trial, it sounds like you prefer the jury trial in a lot of situations, but do you have to kind of, I imagine a lot of businesses would think they prefer arbitration because they just want everything to be private. So do you have to sometimes encourage or coach people to say like, hey, this actually might benefit you to go to a jury?
Absolutely. And listen, if there's an arbitration clause, we don't have to compel it to arbitration. If the plaintiff brought it in court, they might have just waived their right to arbitration. And it gives us a strategic choice as a defendant at that point. And so it's not, it's not always bad. It's just not my preference. It's ultimately a business decision. So laying out the pros and cons for a business owner and saying, here's what your choices are, and make the best business decision that you think, and then we can go from there and we'll see how it goes. One of my cases right now, we brought in federal court. 2 of the defendants were employees. They compelled arbitration, and now we're forced to fight on 2 fronts. And because we're also suing a competitor who took trade secrets, we have to have both of those fights open. And so, your employees are under an arbitration agreement, but under the common law, you don't have that. And so you may find yourself dividing and ultimately, and that's not the case here, but ultimately being conquered because you gave your employees an out to arbitration and you have to fight in courts against other defendants.
Wow. That sounds messy.
It is messy. And then it creates all kinds of questions about where is the discovery in one case? Can it be used in the other case? Yeah. And, but fights are always going to be messy. And so, do you want to give yourself more options or fewer options? And hindsight's always 20/20. So,
sure.
I think there's a place for arbitration. There's an understanding for it, especially international disputes, right? If you don't know what court you're going to land before and you don't know what rules are going to get applied, setting that ahead of time in your terms and conditions or in your contract means at least you know where you're going to fight and the rules you're going to be fighting by.
That's a good point.
But with your employees as a small business who probably doesn't work across a ton of borders, that's not a benefit that you probably need.
Mm-hmm. All I know is I'm glad you're a lawyer and I'm a podcaster. that I can say for sure.
Well, and I'm glad I'm a lawyer too, Kevin. It really is my passion to protect people and their businesses. So, and I'm glad that you're here so we can talk about it.
Well, it definitely comes through. That there's no doubt about that. Your passion comes through very strongly. All right. Well, that's it for today's episode. Court, arbitration, somewhere in between. What matters most is choosing the forum that fits your business and your dispute. If you need help evaluating what's in your best interest, contact Colleen at McKnightLaw.us. Don't forget to like our videos, subscribe to our channel. We very much appreciate you being here. Colleen, I always appreciate your time. Thanks so much.
Absolutely. Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.